moment with us, and thank you for joining us for today's edition. I love to start with stories, and I trust that this story is going to be relatable with you for this conversation. It's the story of Shade. Shade, being a businesswoman, got to her workplace and then found that the place was under lock and key. Upon probing, Shade found that there was an order from somewhere in form of a judgment that was given against her company. And then the place was locked up. Shade never knew of any court matter at all. Shade was never involved, never invited to the court, and was never told anything. So Shade became very concerned and wondered, can people actually be sentenced to some judgment without the opportunity to be heard? Put in another word, can a judgment be given without the opportunity to be heard? This is the conversation that we are having today. And I don't know what your situation is. I don't know what you've experienced over time. I don't know if you have some experience. Of course, let's make this interactive enough. You could get to the comment box and let's share experiences, let's share thoughts, and let's share concerns. The question is, can a judgment be passed against somebody who wasn't given the opportunity to be heard? And interestingly, today we are going to be building a lot of our conversation from 1999 Constitution, which I would encourage that you get your copy. It's titled 1999 Constitution of the Federal Republic of Nigeria. Please get your copy. You need a copy of this to really understand what your rights are. So let's assume that we are going to be having a conversation around Shade, and this conversation affects many people, including you. You need to understand what to do, what are your expectations, among many other things. The foundation to start with is the fact that you cannot be sentenced to a judgment, or you cannot be compelled, or a judgment ordinarily ought not to be given against you without the opportunity of being heard. In other words, where a judgment was even by chance now given against you and you were never heard, you were not given the opportunity to present your case or even know what the case is against you. Where that happens, it is a basis. The fact that you were not informed before that judgment was given is a basis on its own to challenge that judgment and demand that the judgment be uprooted, using the legal language, be set aside, meaning that judgment should be invalidated. And this is one of those opportunities you have. That's of course because we're in a democratic era and the Constitution stands supreme. Now I'm quoting section 36 to our non-lawyer audience. Just for the reference, when you get this, look for so that you understand what we mean by section 36, so that if you have to quote it. Now, section 36 is the first, so you look for the one in bold. Usually, the whichever one you look at the one in bold, which is what we are discussing today. And this is the foundation. The fact that every person ought to be given the opportunity of being heard before a decision is taken, especially in the court of law or any other authority that is dispensing or acting in a judicial capacity. You should be given the opportunity of being heard. And being heard is not just about what happened and then you say blah 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 and that's all. No, part of being heard is that whatever allegation is against you, you ought to be given the opportunity to examine the allegation. And that's the basis, for instance, why if you go to a police station and there is a complaint against you, they will usually bring the complaint out and tell you that you should read the complaint. Now, this is the very foundation. This is one of the reasons that you see that happen most times. They will tell you to read the complaint. As a procedural rule, even police officers are not supposed to be making arrests or inviting people without a proper complaint put in place, because that is the foundation, that's the basis of saying that this is what is against the person, and you must be able to cite what was brought against you. Not just cite it, you must be able to respond, and you should be able to even understand that which is brought against you in a language that you understand. So let's say that somebody, a Chinese man, brought a complaint against me, and I can just read English and maybe I understand Yoruba. Part of opportunity to be heard would mean that you are able to have an interpreter read what was brought against you in a language that you understand. And this is one of the dictates of what it means to be given the opportunity to have that fair hearing, which is the word, the technical word used by lawyers when it comes to the matter we are discussing today. One more. So another interesting thing in this conversation is the fact that part of fair hearing is that you can even represent yourself. When you get a complaint against you, you may want to get a lawyer of your choice, but of course, you know, getting a lawyer of your choice would mean that the lawyer has to be qualified in the first place to practice in Nigeria, and the lawyer, you should also be competent enough to pay the lawyer for what the lawyer's fee would be. So these are essential things that also matters. And at the end of the day, even the law allows you to present your case by yourself, for yourself, especially when it's criminal in nature. So there is a criminal allegation against you. You have a right to present your case. Part of being heard is that even the people that brought allegation against you, you are able to see them, you are able to question them, you are able to defend yourself in the midst of everything. I hope this whole conversation, I hope you find it pretty interesting, because you know, many people fall victim of things like this where they are not even sure of what it is, what is acceptable, what is not acceptable. Then let's come to that other side, the flip side of the conversation. Now, it does not utterly mean that a form of judgment, now we use the word ruling, in the sense that it could be temporary. I mean, nobody can give a permanent order against you when you've not been given the opportunity to be heard. But some people will say a good law deserves to have an exception, and there is no good law without an exception. So now, what are the situations where it could happen that you were not heard before some orders were made? And I'm going to give you examples so that we look through this together. First example is a situation, for instance, where somebody is saying, look, if you do not make that order now, if you don't give this rule, if you don't rule now, something bad may happen that nullifies everything. So I'll give you an example. Let's say that someone's life is at stake, and it's a life and death matter. And then somebody had come to the court to say, look, we need an order to stop these people from continuing to do this thing, because if they continue, this person will die. Now, that can be a basis for the judge to say, oh, let me intervene because of the urgency, because of the fact that life is involved perhaps, and because the kind of damage that would happen if that order is not given may be higher in nature compared to when the judge is saying, well, let me wait for them to come and be heard before I give an order against them. And of course, usually because of the fact that if that order is not given at that time, it may just destroy the whole thing. Imagine if someone is approaching the court and saying, my lord, if you do not give this order now, with tangible proofs, if you don't give this order now, the basis of even coming to court to seek for justice will be destroyed as a whole. In that situation, the court, the judge, can look at the whole thing and then weigh the evidence before the court and then say, yes, I agree with this. And usually, even when that happens, what you would find will be a temporary order. So it's usually not a permanent order that will now leave out, close the door, shut the door against people that ordinarily ought to be heard before an order is given against them. Now, this kind of order is called interim order, and the basis of it usually is because greater damage may be done, there is an urgency and the likes. And this is the foundation. This is the very basis for them saying, well, an order could be given, but a temporary order, or an order that is temporary, of temporary effect and in nature. So I hope you found this conversation interesting today. Remember, the summary of what we are saying is a judgment should not be given without you being given the opportunity to be heard. So you know somebody who is affected by a judgment substantially and was never part of the case. Yes, the person should have a basis to challenge that court action and say, I was not given the opportunity to be heard. I hope you found this interesting. Until we come your way next time, please stay tuned to us and remember to follow us across different social media platforms. Bye for now. Take care.